Ireland.
Closing date for written submissions is the 18th of September, and oral evidence sessions will have to be a priority in October and November. The other bill the committee may have to consider is David McIlveen's proposed private member's bill on reasonable force, protection of life and property. And Mr McIlveen is hopefully going to be here next week to give us a briefing on the results of his consultation on that private member's bill. Arrangements for the range of seminars and events relating to innovative approaches in the justice system that have been agreed by the committee are being taken forward. I would ask members maybe just to note these dates in their diary. A couple of weeks' time, Thursday the 24th of September is the Justice Seminar by Hill. The Hill are the group in The Hague in Holland that myself and Raymond went to see during recess. They do the online dispute resolution stuff, eBay Justice as we like to call it. But I think it's an area that I think we will see progress in across the UK in years to come, and it will be incredibly interesting. So he's coming over to take that seminar. We then have the Conference on Justice in a Digital Age, which will be on the 15th of October. We're holding that in W5. And again, that'll be a good event. I'd mentioned last week, if members can get addresses for schools in their constituencies in, and we'll invite some schools to either link in via video link and potentially maybe get a few pupils to come along to that event as well. Thursday the 22nd of October is our Justice Seminar again. The Centre for Justice Innovation is going to take that one. Again, members who travel over to London on our visit over there, we met with the Centre for Justice Innovation. They talked about problem-solving courts, about youth justice, about the Red Hook Community Centre and things like that. So again, that'll be an interesting one. Thursday the 5th of November we have our event with Lord Newberger, the President of the Supreme Court. Thanks Sammy for his help in getting in touch with Lord Newberger. So that'll be an exciting event as well. He's going to talk about innovation in the justice system and particularly for the judiciary. And we're looking at maybe holding that event somewhere outside the building, but we're still to confirm that. And then finally we have our event on Thursday the 26th of November, which is the evening event with Lord Levison. Again, members who were over in London know that he said he would be willing to come across and talk about innovation in the court system. So we've taken him up on that offer, and we're going to hold that event here in Stormont in the Great Hall. So again, there's some nice events that we have planned outside normal committee business. So all being well, we'll be able to progress those in the next couple of months. So members, just note the forward programme. As I said, if you can get those addresses to schools in your constituencies in as soon as possible, because you want to get our invites out hopefully at the end of this week. Item 2, Justice Number 2 Bill, Supplementary Research Paper and Fine Collection and Enforcement Mechanisms. If you want to look at pages 33 through to 111 of your packs, at the meeting on the 23rd of June, the Assembly Senior Researcher outlined the key points in the research paper commissioned by the Committee on Fine Collection and Enforcement Mechanisms in other jurisdictions. During the briefing, the committee requested further information on a range of issues, and a supplementary research paper has been provided covering 3 of the 4 issues. In relation to similar information that contained in the table on page 12 of the original research paper, for other years apart from 2012, research has not been able to locate any. So that's really just for noting, unless anyone has any further clarification required. Item 3 is a response from the Department providing information and statistics requested by the Committee in relation to the proposals to rationalise the Courts estate. If I refer to pages 72 through to 86, the Department has provided information and statistics requested by the Committee following the oral evidence session with the councils that we held on the 2nd of July. The information includes utilisation rates for 2010 through to 2014 for all court venues, analysis of the number of sittings, average list size and sitting times for courtrooms within venues based on the business type and available information on the impact of the closure of Bangor and Larne hearing centres and other courthouses. So again, this is just for noting. The Courts and Tribunal Service are due to attend in November to brief the Committee, so we'll return to it at that point. Item 4 is correspondence from Mid and East Antrim Council. Can I refer to pages 87 through to 109 of your folders. The Council has provided a range of further information, including a list of questions it asked officials following the oral evidence session on the 2nd of July. The Council also reiterates its call to halt the current proposal to close Ballymena Courthouse and requests a strategic review of justice services across Northern Ireland and consideration to be given to an options paper that is provided as the way forward. So again, that is for noting. Item 5 is an invitation from Derry City and Strabane District Council to visit Omagh and Strabane courthouses, again following the oral evidence session that we held with them. I refer to pages 110 and 111. Following the oral evidence session, They invited us to go and visit those courthouses, saying it would be very informative and assist us with scrutinising the proposals. Now, given that we have an incredibly heavy workload, and we discussed this at the strategy day last week, I would propose that if any members wanted to do that, then we let the committee staff know and we'll arrange for them to go together. So rather than doing a formal committee visit, if members want to go along to it, we can arrange something for a few members to go along when it suits them. Move on then to agenda item 5, because we've scrapped 4. The departmental officials are attending to outline proposals for a targeted consultation on general provisions on enumerating exceptional circumstances in cases in the Crown Court. If members want to go to pages 135 through to 162 of the meeting folder, we'll welcome the two Mark McGuckins and Patrick Cullen. And again, we're going to Hansard this session, so whenever you're ready, you can brief the committee.
Thank you very much, Chairman, for your introduction. And you've already introduced myself and my two colleagues. The purpose of our attendance at the committee today is to brief you on developments in dealing with remuneration in exceptional cases in the Crown Court. And I'll keep my comments brief because most of the details in the document that you'll have already seen. You will recall that when we appeared in April, we advised the committee that we were considering our response to the outcome of several judicial reviews, which concluded that the existing rules could not provide an appropriate fee in the very specific circumstances of the individual case involved. We were considering whether to introduce a specific fix for these cases or to introduce a more general provision. And we have now developed proposals to introduce new general arrangements to remunerate work which falls outside the standard fee approach. That was very much informed by the successful judicial challenges which had occurred earlier in the year. And the Minister decided that rather than try and deal with each of those individually, to go for a general provision. The consultation document sets out in some detail the background and the fees which are currently available in a comprehensive and sophisticated standard fee approach. It sets out proposed provisions as to what would constitute exceptional within the new arrangements. It sets out the process which will be applied to applications, and it sets out how the additional work will be remunerated. And finally, it makes proposals for an appeal mechanism should there be dissatisfaction with either entrance to the scheme or the actual amount being paid in a specific case. Just to draw out the key points, they are that defence representatives will be able to apply for consideration of exceptionality where it can be shown that specific elements of a case fall outside the standard fee approach, where the case involves a point of law or factual issue that is very unusual or novel, and additional work is reasonably required on the part of the representative in order to prepare a defence, and that work is substantially in excess of the amount normally required for cases of the same type. The Minister is keen to implement the new arrangements quickly, not least in order to respond to the recent successful judicial reviews. Consequently, we are proposing a targeted consultation with the statutory consultees and with the Law Society, the Bar Council and the Director of Public Prosecutions. We are proposing a 4-week consultation period, and during that period we plan to engage with the legal profession on the detail of the proposal. Mr Chairman, these are important proposals which have been developed following detailed consideration of the issues and reflecting the comments which were made during the various judicial reviews, and I'd be happy to address any questions from the committee.
Okay, thank you, and thanks for keeping it brief. Raymond, question?
Just in terms of briefing note, is it the 3 points or each them separately?
It will be the 3 points together. That there is an issue which is of law which is novel or an unusual set of facts, and that it requires additional work to be done in order to prepare the defence, and that is in excess of what's available through the standard fee. The standard fee is actually quite sophisticated and extensive in terms of what it can provide remuneration for already.
And excuse my ignorance, what's the difference between a factual issue and an issue of fact?
Well, that's a very interesting question, and effectively any case can have a novel fact in it. It's unique to that particular case, the set of circumstances, but it isn't really a novel fact in the general sense. And what you're looking for in terms of unusual factual issues is where a range of things come together which make the case much more complex and difficult, and require a significant amount of additional research in order to prepare an appropriate defence to the issues involved. So it is a range of things, effectively, which can come together. It's impossible to set down what each of those might look like, and it will depend on the circumstances of the case. And it could, for example, involve a very novel new forensic approach, for example, that hasn't been tested out before and hasn't gone through a judicial system. So, that sort of area.
So if there's a new forensic method being used, then
potentially, depending
the exceptional circumstances.
Depending on that, but that would be an example of the sort of thing that would be considered then by the agency.
Okay, thank you.
Okay, anyone else?
Just a quick question. Do you see any resistance from the legal fraternity, Mark?
Well, I wouldn't want to predict the outcome of the consultation. The proposals have been drafted reasonably tightly because they're not intended to replace the existing system. The existing system is there, it's robust, and provides standard fees in most cases. So the proposals have been drafted fairly tightly in order to ensure that genuine exceptional cases can be considered as appropriate for an additional remuneration that might be required. I would like to think that the legal profession would embrace this as an opportunity, and we look forward to engaging with them. The intention would be that we issue this consultation document once the committee is content that we proceed on that basis, and engage quickly with the legal profession over the course of the next 4 weeks to go through the detail and address any issues which come out.
Okay, everyone else happy enough? Okay, thank you very much. We'll consider it again. The results come back in, but appreciate your time. Thank you.
Thank you.
Okay, members, are we content then with the proposed 4-week consultation take place, and then we'll consider it further when the results are in? Yeah. Okay, move on then to agenda item 6 is the Land Tribunal Amendment Rules, Northern Ireland 2015, referred to pages 164 through to 193 of your folder. Having considered the matter on a number of occasions and received an oral briefing by the Courts and Tribunal Service officials at the meeting on the 12th of May, the committee agreed that it was content with a proposed statutory rule to amend the fees charged by the Land Tribunal for Northern Ireland for non-domestic rating valuation appeals and for administrative services to achieve full cost recovery. Statutory Rule number 2015/302 was laid by the Department on the 9th of July and is subject to the negative resolution procedure. There have been no changes to the policy content since ASL1 was submitted to the committee, and the examiner of statutory rules has indicated he has no issues to raise with regard to the technical aspects of the rule. Can I therefore ask members if they are content with the rule? And if they are, I'll put the question that the Committee for Justice considered statutory rule number 2015/302, the Lands Tribunal Amendment Rules Northern Ireland 2015, and has no objection to the rule. Are you agreed? Okay. Move on then to agenda item 8, disclosure of victims and witnesses information. Can I refer members to pages 203 through to 213 of your folders. Section 36 and Schedule 3 of the Justice Act makes provision for relevant information about victims and witnesses to be automatically shared by the Police and the Public Prosecution Service with prescribed bodies to ensure that victims and witnesses of crime are provided with information at the appropriate time about available services and can make informed decisions about whether or not to avail of those services. The Department is proposing to make a statutory rule to prescribe victim support NI for the purpose of enabling relevant information about victims and witnesses of crime to be disclosed to them, and to prescribe NSPCC for the purpose of enabling relevant information about witnesses of crime to be disclosed to them. The statutory rule will be subject to the negative resolution procedure in the Assembly. The statutory rule will enable Victim Support Northern Ireland and the NSPCC to contact victims and/or witnesses directly to explain and offer their services. There will be no obligation to avail of these services. So, again, are members content with the proposed statutory rule, or is anybody any further information that they wish to seek from the Department? Happy enough? Yep.
Yep.
Okay. Agenda item 9, can I refer you to pages 215 through to 337. Following a recommendation from the committee, following the inquiry into criminal justice services available to victims and witnesses of crime, the Department of Justice gave a commitment to provide for a statutory victim charter. The Victim Charter was subject to public consultation and introduced initially on an administrative basis on the 31st of December 2014. The Justice Act 2015 provided for the Charter to be laid at the Assembly and placed on a statutory footing once the date of coming into operation has been affirmed by the Assembly. The Department is proposing to make a statutory rule which will bring the Victim Charter into operation now that the necessary provisions in the Justice Act have been commenced. The statutory rule will be subject to the draft affirmative procedure in the Assembly. So again, are members content with the proposed statutory rule? Yep. Okay. Agenda item 10, Justice Bill 2, Delegated Powers Memorandum. Can I refer you to pages 339 through to 472 of your folders? The Department has provided a Delegated Powers Memorandum relating to the Justice No. 2 Bill, which identifies the provisions in the bill which confer powers to make delegated legislation and outlines the reason for taking each power and the nature of it. As indicated by the Minister during second stage debate, the Department intends to review Clause 45 of the bill in light of the changes made to a similar provision in the Justice Bill first time round. To assist consideration of the delegated powers in the bill, the committee may wish to request the views of the examiner of statutory rules on the powers to be left to subordinate legislation and the Assembly control that will apply to each. So, if members are content, then we'll refer the delegated powers memorandum to the Assembly examiner of statutory rules for a report highlighting any issues that the committee may wish to consider. We agree that we take that approach. Yep. Just to remind the committee, at the meeting on the 12th of May, the committee noted the Department's proposed consultation documents on its quality impact assessment and regulatory impact assessment of the financial penalty default collection and enforcement legislation. The Department received 3 responses to its consultations and has now provided a report which indicates that its assessments remain that the mitigations provided in the bill, the provisions meet its Section 75 requirements, and the proposals have no impact on employers, banks or financial institutions based on the cost recovery provisions, and limited impact on the legal profession while making savings to the public purse. The Minister therefore is content to proceed with the legislation as proposed. So again, can we, if members are agreed, we'll note the Department's report on the responses to the consultation on its quality and regulatory impact assessments, and advise the committee that there will be an opportunity to explore any issues in the report when we have officials attending during committee stage of the bill. So are we content? Agenda item 11 then is the Northern Ireland Human Trafficking and Exploitation Strategy 15-16, summary of consultation responses and revised draft strategy. If I refer you to pages 474 of your packs, the Department has provided a summary of the responses received to the consultation on the draft Northern Ireland Human Trafficking and Exploitation Strategy 15-16 and a copy of the revised strategy. The Department has indicated that the responses received were broadly supportive of the overall strategy. A number of respondents put forward some suggestions for amendments, and these, for the most part, sought to add to the strategy rather than detract from elements of it. The Department has provided a table of all consolidated comments and recommendations from the consultation exercise, which also sets out the Department's response to each of the comments received, including whether a suggestion or recommendation has been accepted and where it hasn't been, the rationale for that. In light of the responses, the Department has made a number of revisions where it believes it would enhance the strategy, it's a priority and it's achievable. The changes are highlighted in yellow. Subject to the Committee's consideration of the final strategy, the Department proposes the publishment on the Department of Justice and Organised Crime Task Force websites in mid to late September. So, members, can we note the results of the consultation on the draft Northern Ireland Human Trafficking and Exploitation Strategy? We're happy enough to note it, or if members have any comments to make? No? Okay, happy to note then. Agenda item 12, Police Injury Benefit Regulations, refer to page 757 through to 799. The Department is proposing to carry out a targeted consultation on draft regulations for a new Police Injury Benefit Scheme. The new Injury Award Scheme proposals involve changes to bring the Police Injury Benefit Scheme more in line with schemes across the public sector, while continuing to recognise the unique nature of policing in Northern Ireland, and aims to create a better administrative system with criteria suitable for modern-day policing, which provides appropriate assistance to police officers and their families. The Department will update the Committee following the consultation responses and intends to introduce the new regulations, which will be subject to the negative resolution procedure in early 2016. So are we content for the targeted consultation to take place, and then we'll consider the issue further when we've got the results of that. Happy enough?
Okay.
Agenda item 13, Department of Justice Corporate and Departmental Business Plan 1516. If members want to refer to pages 801 through to 955 of the main folder. The Department has provided a copy of its finalised corporate plan for 2012 through to 2016 and business plan for 1516. The period of the corporate plan has been extended for 1 year to 2016 to align with the programme for government period. A copy of the Department of Justice Annual Report and Accounts for the year ended 31st of March 2015 is also included at pages 828 through to 955 of your meeting folders. Our members in agreement that we request a written update on the current progress and work being undertaken in relation to each of the measures in the business plan. Yep. Happy enough?
Yep.
Then item 14 is the Attorney General's draft human rights guidance for the police service. Refer to page 957 through 966. The Attorney General is required under Section 8 of the Justice Northern Ireland Act 2004 to issue guidance to named criminal justice organisations on the exercise of their functions in a manner consistent with the international human rights standards. During the last Assembly session, the Committee agreed that it was content with the proposal to add the PSNI to the list of organisations and agreed the statutory rule required to make the change. The Attorney General has now provided the draft guidance he has prepared for the PSNI relevant to the protection of life for consideration by the Committee. The guidance is intended to assist the PSNI in discharging its duty to protect the lives of police officers and other employees from dangers arising from the criminal act of third parties, and in preparing the guidance, the Attorney General's staff have liaised with PSNI officials. So can I ask the Committee if we are content with the Attorney General's draft human rights guidance for the PSNI? Okay, and then once those guidelines are finalised, the Attorney General will lay the draft guidance in the Assembly and provide the Committee with details of the proposed statutory rule that will bring it into operation. Agenda item 15 is correspondence. Can I refer members to their packs of 34 items from pages 967 through to 1182. And there's 2 items at pages 3 to 37 of the table packs. There's a few items I'll just draw the Committee's attention to, and if anybody has any other particular items of interest, they can raise them. Item 5 is at page 1056. It's a response from the Department in relation to the NAACRO Job Track programme. The Department stated that it recognises the value of the Job Track programme and was disappointed that NAACRO was unsuccessful in its bid to the European Social Fund. It has highlighted that whilst the prison service is unable to meet the shortfall, officials have been working with NAACRO to identify other options to deliver employment support for people in custody, and have recently approved a revised proposal to establish 3 NAACRO placement support officers in each prison establishment. The Prison Service has also written to the Department for Employment and Learning to request a meeting to explore how it can work more collaboratively to address the gap following the unsuccessful ESF bid. So that's really just for noting. Item 7 is at page 1061. Is a response from the Department to the Committee's request for further information regarding the delay in the development of a joint healthcare and criminal justice strategy. The Department has indicated that the original timescale to submit the draft strategy to the Ministers, the Executive and Committees was in autumn 2014, with it to be published in the spring of 2015. The Department's advised the reason for the delay related to the DOJ's concern that the issue of social care and prison custody required further consideration and additional issues that emerged. The Department has now provided a revised timescale to achieve the launch of the strategy by November 2016. So again, that's just really for noting. There will be an opportunity to discuss this matter with the independent members of the Prison Review Group and the Prison Service when they attend next month. Item 18 is at page 1102. It's correspondence from the Department of Finance and Personnel. It's in relation to funding for the Desert Creek Community Safety Training College. DFP has provided further clarification that access to the 53.3 million accumulated end-of-year flexibility stock is subject to Treasury agreement. The return of the 30 million funding provided by the Executive will also be a decision for Treasury, and a present agreement is not in place to return the funding. So again, this is to note, we do have an oral briefing on Desert Creek planned for later this month. I know it's particular interest to Patsy, but that's just really for noting, and we'll be able to look at the detail of that later on this month. Item 24, page 1163, is correspondence from the Director of Public Prosecutions providing further information in relation to guidelines for responding to elected representatives. The number of cases handled by PPS where the witness was accused of withholding information, and information on the number of cases where decisions were overturned following a review following the oral evidence session on the 11th of June. So again, that's just for noting. I think it was raised by Mr Douglas at the time around the protocols that were in place, so that can be useful. Item 25 is at page 1165. It's a copy of a letter from the Chairman of the Prison Officers Association to the Director of HR, Finance and Corporate Services of the Northern Ireland Prison Service in relation to the unresolved issue of payment of the pay award. Despite the decision by POA membership to withdraw goodwill and cooperate with management, they have decided to delay the implementation of the ballot until representatives met with the Minister of Finance on the issue on the 18th of August. I understand that there's been some progress on this issue, but if members are in agreement, we will write to the prison service and get a updated position on where things stand at the moment. Item 27, page 1166, is correspondence from the Division of Forensic Psychology inviting the Justice Committee to a presentation by Dr Ruth Mann, Head of Evidence in the Directorate of Commissioning and Contract Management, on evidence-based policy in relation to prison community offender programmes. It's going to take place on the 1st of October here in Parliament Buildings. I've agreed to sponsor the event, and if anybody wants to go along to that, just let the committee staff know, but it could be quite interesting. Item 30 is at page 1172. It's an invitation to the launch of gender principles for dealing with the legacy of the past. That's on the 15th of September in Parliament Buildings. It's an independent initiative made up of a diverse multidisciplinary group of individuals with different perspectives and affiliations, and is supported by the Reconciliation Fund of the Irish Department of Foreign Affairs and Trade. So again, if any member wants to go along to that, just let the committee staff know. Item 31 is page 1173. It's an invitation to the launch of the Conference Report and Model Implementation Bill on dealing with the past in Northern Ireland, implementing the Stormont House Agreement organised by Amnesty International Northern Ireland and the Committee on the Administration of Justice, Institute of Conflict Transformation and Social Justice at Queen's, and the Transitional Justice Institute at Ulster University. That's on the 16th of September at the Ulster University in Belfast. So again, if anybody wants to go along to that, just advise the committee staff. Item 32, 1175 through 1176 of your meeting folders is correspondence from the Northern Ireland Human Rights Commission, providing a copy of its research report entitled Alternative Care and Children's Rights in Northern Ireland. The report is wide-ranging, and the conclusions contain 29 recommendations, including legislative reform, data collection and arrangements for secure care accommodation. So that's really just for noting. Item 33, 1177, is correspondence from the Children's Law Centre, providing copies of the Northern Ireland Young People's Report and Northern Ireland NGO Alternative Report to the UN Committee on the Rights of the Child. The NGO Alternative Report highlights a wide range of children's rights issues in relation to justice and policing for children and young people. So again, those are just really for noting. Then on the tabled papers, item 1 at page 3 through to 33 is a report by the Criminal Justice Inspection Northern Ireland on adult safeguarding. The approach of the criminal justice system to investigating and prosecuting crimes against vulnerable adults, published on the 9th of September 2015. And again, that's for noting. Item 2 is a letter from the Committee for the Environment regarding the launch of Northern Ireland Environment Week on the 21st of September. A programme of events on Tuesday the 22nd of September in Parliament Buildings, and members are invited to attend the launch and the other events that they are holding. Any members anything to raise in the other items of correspondence? No? Okay, and members are agreed we'll action the correspondence as outlined in the pack. Agenda item 16 is Chairman's Business. The item 1 is an Ulster Bank Conference on Fighting Fraud through Awareness Programme. I've accepted an invitation to attend an Ulster Bank Conference in association with Lisburn and Castlereagh City Council on Fighting Fraud through Awareness on the 6th of October in capacity as Chairman. We will be addressing some of these issues, I suspect, as well in our cyber conference around cybercrime and around the threats there is for online fraud and identity theft and how banks protect themselves and things like that. So they may also be interested in attending our conference as well. Agenda item 17 is any other business. Has any member anything else? Sure.
Just very briefly, Chair, given the investment that's been made in the cyber conference, regardless of the status of this establishment, it would seem very remiss of us not to proceed with that, even if it had to be done in a informal or shadow format. But I think, you know, the delivery of it is important, and you've issued an invitation to schools, and we would want to bring schools along to that event. So perhaps afterwards we should have a conversation with Clark just to see how it could be progressed in the light of events perhaps later today.
Sure. I'm going to have to do that. Okay. Any other members? No?
Chairman, could just
Sorry, yeah.
in relation to what's happened later on in terms of adjournment or whatever, what's the situation in terms of adjournment for this committee? Because I think it's the same as recess, that if we wanted to meet, we could do that. Is that correct?
So if there's an agreement that we adjourn the assembly, the committee can still meet, and we will be able to proceed with our own events that we have planned. My preference would be that we continue to meet as a committee if we adjourn, because I think we've got such a huge workload that we need to get through it. It may actually help us out when some of the responses to the Justice 2 bill come in. 18th of September is the closing date for that, so it would allow us maybe a wee bit of time to work through some of that stuff and knock it off, so that we're not here till 6 or 7 o'clock in the evening once we try to get through all of that. So if we get to the point where there is an adjournment, I would suggest that we do that, and it would allow us to continue on. Obviously, if it's...
And that decision would be made by the committee, that'd be right, if we wanted to. Maybe make that decision. Yeah.
Obviously, suspension would be a different issue, and we wouldn't. The committee wouldn't exist anymore. So, but we can but hope. We'll know it on our, so I would suspect. Any other item of business? Are we happy to go on to agenda item 18, date, time, place of the next meeting? All being well, it will be on the 17th of September at 2 p.m. In this room. So thank you very much.
This is the Northern